Let me bring in my think tank tonight. I've got criminal defense attorney Danielle Moss with us, chief jailer and former section commander for major crimes, Lieutenant Colonel Adam Lee, and criminal defense attorney Lawrence Zimmerman as well. Great to have everyone here. Let me begin with you, Lieutenant Colonel. I'm talking about a jailer's brought in today, death penalty case, 2.5 hours sleep. Why do they have to sometimes wake up that early if court doesn't start till like 9?
Well, there's bound to be more than one defendant going to court. He's not the only person, so I'm not sure how large their jurisdiction is there. They have to get everybody up and ready for a transport that's going to occur.
What goes into that? What goes into the whole process of getting them ready for transport?
A lot of security. A lot of security takes place. You have to make sure that all of the defendants are ready to go to court, prepared. Some of them have to change their clothes. Of course, you don't want to appear in court in your orange or your whatever color jumpsuit the jail uses. You don't want to appear like that, so they have to change clothes. There's a lot that goes into it, so I'm sure he's not the only person going to court. And
it's 5 a.m. reasonable, you think?
That's very reasonable.
Okay,
very reasonable.
Okay. Now, this defendant wrote a letter to the judge also, and I want to go over some of the things and requests that he made and get your take on it tonight, because it's kind of interesting. One, let's go with the first one, put it up there. And he says, here at the Orange County Jail since my arrest on October 1st, 2017, and this letter is from April 27th of 2018, I've lost 40 pounds of weight. I've lost 40 pounds of body weight because I don't get enough food. Have you ever seen that? I'll start with Lieutenant Colonel, then bring the lawyers in on this one. You ever seen that?
I've seen people lose weight from stress. I've seen inmates lose weight from forced starvation diets. There's a lot of depression that's going on, you know.
But how about a guy who says you're just not giving him enough food? You ever had that?
That's very doubtful.
That's
very doubtful.
Lawrence, have you had any clients who happen to be locked up before trial that maybe lost some weight?
A lot of times it's actually the opposite. I've had a lot of clients complain about the food at the jail, so they have to go to the commissary. They're buying Snickers bars, Twix, chips, and they're gaining weight because they can't eat anything good other than high-sugar foods.
Danielle, have you ever seen, is this a problem? Is weight an issue with...
It's never been an issue with any of our clients. I agree with Lawrence that more times it's that they've gained weight.
Okay, now, here's something else that happened. Again, this is the letter he sent to the judge. Judge, I've provided a full confession, gave up unsolved armed bank robberies, and promised to divulge 8 homicides. He's writing this in a letter. How much is this a problem, perhaps, at trial?
It wouldn't be a problem at trial, but I mean it's problematic for him to be having any type of communication with the judge, and the fact that is
there anything lawyers can do to stop this?
You can try and rein in your client, but if he wants to shoot himself in the foot, he's going to.
This is he says he's promised to divulge 8 homicides, kind of indicating here that he killed 8 more people in unsolved cases. If your client wrote something like this, what would you do with that?
Well, what the client's trying to do is try to negotiate a position here. And you got to remember, in a death penalty case, many times you're not trying to get an acquittal of the client, but you're trying to get a life sentence or life with possibility of parole. That's usually the strategy, and I've done death penalty cases before. That's usually the strategy going in. So it sounds like that's what he's trying to negotiate right there. Why is this happening to me? Here's all the things I've done. Here's what I want in exchange. He's trying to open the door, which I'm sure his lawyers have already tried.
Now, here's the most unbelievable one. Well, maybe not, but legally, what's going on? Why this trial is taking place now? He writes to the judge, under no condition do I wish to waive my right to a fast and speedy trial. I want to testify on my own behalf at trial. I want to speak on my own behalf at the penalty phase. He's already at the penalty phase, Danielle. He's already there. And is there any way that a lawyer could stop him from testifying? You can't, right?
No, he absolutely has the right to testify, and if he wants to do that, he's going to. I mean, you can put it on the record. I haven't done it myself, but there have been limited circumstances where you can put on the record the fact that you've advised him not to take the stand, but if he wants to, he can exercise that right.
He also wants to speak on his own behalf at the penalty phase. Lawrence, it seems like this is a defendant who knows he's going to be convicted already. Well, I guess he's confessed also.
Yeah, so to Danielle's point, someone who's charged with a crime has certain rights, and to testify is the #1 thing that they have a right to trial. That is not the lawyer's decision. There's absolutely, the judge will tell them that. You have this absolute right. Nobody can tell you any differently. You have a Fifth Amendment right not to testify. So, but you have to advise the client. If the client doesn't want to listen to you, put it on the record in a closed proceeding, and it is what it is.
I have one other question about letters coming out of the jail. Do they generally go through some sort of security, a letter going out? Does it get read, and do letters coming in
There's
get
a
read?
process where the letters get read coming in. Any legal mail is not subject to examination.
So if you're sending it to the judge or to a lawyer?
The jail, no one at the jail can open up a letter that's considered legal mail. So if that mail is going from client to defendant, or from, in this case, defendant to the judge, we would not be looking at that.
All right, so next big case, folks, coming up here on Court TV. Switching gears right now to some breaking news. Jose Baez, you may remember him from down in Central Florida, right? Well, he's one of the movie producer's last remaining attorneys for Harvey Weinstein, and has asked New York Supreme Court to allow him to withdraw from the case. Court TV has confirmed that the court has received a letter of recusal. Weinstein is accused of rape and sexual assault of 2 women in New York. His trial is scheduled to begin in September. So here you have another member of this team, and at one point, and he's had some really good attorneys on his team. He had Benjamin Brofman, one of New York's best defense attorneys. I mean, he's a pit bull, represented Michael Jackson and P. Diddy and others. Now Jose Baez, who won the biggest case of this century. You've got Ron Sullivan, Harvard professor. He also withdrew. So what's going on here? Is this a lawyer problem or a client problem?
Client problem. Red flags everywhere. When somebody calls you and says, I've had 4 prior lawyers, run. I mean, that's what's going on. You have a Harvey Weinstein, who's obviously a control freak, just based on what we know about him.
It sounds like he's trying to produce his own trial here. And what happens when you have a client like that, a guy who's used to running everything?
I normally get out of the case. If he can't hear my voice and he's not going to listen, or she, to what I tell him to do, then I'm of no help to him and I'm of no service. And it's best for me to get out, and hopefully you can find someone who will convince him to do the right thing and abide by what the attorneys want him to do.
Now, according to Jose Baez in the letter that he sent to the court, part of the problem was communication. His client, Harvey Weinstein, is communicating with him through outside counsel. That's a problem, right?
I've never heard of that before.
It's crazy. It's crazy, right?
It's crazy.
And then Jose Baez also said there were some issues involving money as well.
There it is.
Now, wait. If you enter an appearance on behalf of a criminal defendant, right? And then there's a dispute about money being paid to you as a criminal defense attorney, can you get out of the case automatically, or what happens?
In Georgia, generally, in criminal cases, if you're not paid, that's not a reason to get out of the case. So you're usually stuck. Once you file an entry, unless there's some other reason, most judges are not going to let you out of the case.
Because of money?
Because of money. You're stuck.
You're stuck.
You're stuck.
You're in
okay, so if it's, I got to think that Harvey Weinstein doesn't want him either, because Weinstein's PR people put out a message saying there's some new team coming together. But this is now scheduled for September. Do we think this happens in September? They've gotten it pushed a bunch of times because of Weinstein's team not ready. What do you think?
I think at a certain point the judge is going to say, put up or shut up. I mean, how many attorneys can you go through? If they can show that actually they're doing it in an effort to halt the trial or to give themselves some more time, I would think most people would say, look, for the sake of judicial economy, we got to move this thing.
We got him. And there's victims, and there's people who have to, schedule this. He does have local attorneys, Arthur Aidala and his wife, Marianne, and they're great attorneys, so they could try the case themselves, but I think he's going to bring in more to join this dream team of sorts. Anyway, folks.